Hi, this is Dave Tannen, and this is the next in my series of talks on Georgia family law issues. Today I'm going to be talking about custody in Georgia. Custody in Georgia breaks down into two components. First is legal custody, which is really just decision making, and then the second is physical custody or parenting time. In terms of legal custody, the overwhelming standard is that there will be joint legal custody, which means that before either parent makes a big decision affecting the child, the parents have to discuss it. There are four areas in which the courts have said, listen, there's so much disagreement between parents as to these major issues. We're going to need a final decision maker or a tiebreaker. And that is non-emergency health care, education, religion, and extracurricular activities. Now, there's a variety of formulations as to how these can be allocated between the parents, and that is something that would require further discussion with myself or another attorney on your behalf. In terms of what it means to have joint legal custody and talking about the issues first, the best example that I can give is that you are to communicate with each other. And obviously, if you're going to take into account future litigation, the best way to verify that such communication has occurred is to do it by text or email. There's a record at that point. The alternative to that, by contrast, is sole legal custody. Sole legal custody occurs generally when one parent is impaired or in prison or so far away, discussions really can't be had in a timely manner. And in that case, the parent with the decision-making authority doesn't have to discuss it with the other parent. Turning now our attention to physical custody, again, which in Georgia is simply parenting time, there are three basic levels of parenting time. There's sole legal custody, which means, as it says, the person who has sole physical custody, has 100% of the parenting time. There's primary physical custody, where one parent has more than 50% of the parenting time and the other has less than 50% of the parenting time. And then there is joint legal custody, which is basically parity in parenting time, 50-50 each. Again, like with legal custody, courts are hesitant to award sole physical custody absent some significant showing of danger to the child or other reason of significant importance. With respect to primary physical custody, that is the traditional standard. Back in the day, 80-20 split was the norm. Dad traditionally got one night a week every other weekend. You'd split the holidays and split the summers and have some vacation time thrown in, with mother having 80% of the time and dad having 20% of the time at the end of the day. Most judges still prefer a primary parent, but they are allowed certainly to award joint physical custody, which allows for 50% parenting. And given the increasing for the good involvement of fathers in the lives of the children overall, that 80-20 standard is really somewhat dated, I would say. And if the parents aren't getting 50-50, they're becoming much closer, 60-40, 70-30, 55-45. And if you go online, you can pick out a variety of parenting plans for nights of the week, etc. And you're really limited by your creativity in that regard. In terms of 50-50 parenting, it is pretty much what it says. And again, there are a number of formats to achieve that 50-50 parenting. Courts, rather judges, are hesitant to impose that overall in my experience. However, if the parties consent to it, meaning they do it by agreement and ask the judge to approve it, as opposed to the judge coming down and saying, hey, this is what you're getting, the courts overall and judges will generally approve it. In terms of if there's a big dispute or you can't come to a decision on your own and the courts are looking at the parenting time, the courts are going to be guided by the best interests of the children standard, what is in the children's best interest, and they're going to examine attachment issues, uh, historic parenting roles, uh, who the psychological fitness of the parents seems to be better with, and any number of factors. And it'll include, of course, the mundane factors, the basic factors of who can provide who can provide housing, who can provide, be there for the kids because of their work schedules, etc. The courts make clear that money isn't a determinant factor in this. It is the ability to provide basic housing and basic support, not to provide someone living in a mansion versus someone living in an apartment. Courts make that very clear. If the parties feel that it's necessary, or the court feels that it's necessary, the court will appoint a special investigator called a guardian ad litem to investigate all these issues and make a recommendation both as to physical custody and as to legal custody. Ordinarily, the cost for the guardian will be paid by the parties. However, if it's a low-income family, certain of the courts and certain of the counties have the ability to appoint a guardian who will work for free or pro bono. The judge does not have to accept the guardian's findings. However, ordinarily, the judge gives them great weight, and ordinarily you will find, or I have found, that the party that veers the most from the guardian's recommendation loses the most in court. That said, there are cases where the guardian's findings are rejected in whole or part, and each case has to be evaluated on its own. That is it for child custody in Georgia. I hope you found this informative, and I will be speaking again with you soon.